The first matter to come before the court this morning is in re LP, and AS. The appellant will have 15 minutes, well, both sides will have 15 minutes to present the argument. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve any time for rebuttal, I'm keeping the clock this morning. I can keep you apprised of the passage of time. We read the briefs when we were ready to see who you are.
Thank you, Your Honor. May it please the court. My name is Neil Agrawal. I represent the father of Lorenzo Fair. I reserve 3 minutes for rebuttal. Your Honor, the agency, Department of Job or Summit County Children's Services Board, CSB, they filed a complaint in October of 2013 involving these children. The magistrate at the juvenile court found the children dependent in January of 14. Objections were filed by the father, which was not ruled on by Judge Teodosio until June of 14. 3 months later, the agency filed for permanent custody. Prior to the permanent custody trial, the father then filed a motion requesting a final appealable order from the objection ruling, arguing that when the judge issued her ruling from the objections, she included, it was only half. It only had the rulings from the adjudication. It had nothing related to the dispositional ruling, which is required to have a final appealable order, because and the reason is a final appealable order has to have an adjudication and a disposition. It must be in one document, and it must not refer to other documents to determine the party's rights and obligations. During the permanent custody, we again argued that, Your Honor, respectfully, we need a final appealable order from the original adjudication. The judge said she would take it under advisement, and then she granted permanent custody, and as far as the final appealable order, it wasn't mentioned in any way, shape, or form. She didn't say it's denied or not in good faith or whatever. It was just quiet. So we're here today saying respectfully, we don't think this court has even jurisdiction to hear this appeal, because we don't have a final appealable order from the original adjudication. Now, I have cited in my reply brief an exact factual case from this court, where in that case, Judge Teodosio also ruled on objections, also said in her ruling, prior rulings are in effect. The parties appealed to this court, and this court said it's not a final appealable order, case dismissed. And I have a copy of that journal entry as the appendix in my reply brief. Now, the state is not really disputing this. What they're saying is what the father is arguing only applies if it's a delinquency case. Once you have a delinquency, you need a disposition, because that's like a sentencing. But for a DN case, abuse, offense, and neglect case, you don't have to have a disposition. You can appeal immediately from the adjudicatory decision. Now, there's no case law, there's no statute, there's no rule to support that position. However, personally, I do a lot of juvenile appeals. I would love it if this court says, you only have to appeal after adjudication. You don't need to wait for a disposition. But in reality, that's not the law. The law is you need to have both. They both have to be contained in the four corners of one document. And then and only then can the court, is that a final appealable order to proceed. And that not being done, we don't think, respectfully, this court can hear this appeal. However, there's no other option for my client to have the remedy taken care of, because I asked the court for a final appealable order and they didn't grant it. They granted the PC. So at that point, I have to take it to this court to hopefully tell the trial court, please issue a new final appealable ruling. Moving on to the second assignment of error. During the permanent custody trial, or I should say at the end of that trial, the prosecutor said, here's a bunch of journal entries. These belong to the father, and we want the court to admit them into evidence. No one testified about these journal entries. Nobody authenticated them. Nobody identified them. Nobody connected them to the father. It just said, here they are, and we want you to have them introduced into evidence, or have them introduced. I objected, or the father, I should say, objected, saying there is no link, there is no connection between this journal entry and the man sitting next to me, the father. How do you know this Lorenzo Fair is this Lorenzo Fair? And the trial court overruled it, admitted them into evidence. I'm arguing, and I cite case law from this court that says a name alone is insufficient to link the defendant to a prior conviction. Courts have found that a combination of identifiers, such as a birth date and social security number, is sufficient to establish identity. The journal entries that were introduced did not have any date of birth, they did not have any social security, they had nothing to say that the man in those journal entries is the man sitting next to me. The court introduced it anyways, and we say that was improper. Third assignment of error. During the trial, the permanent custody trial, there were a couple of psychologists who testified from the Northeast Ohio Behavioral Health, or NEOBA. They presented a portion of the records and the evidence, and during cross-examination, it was determined that they're not complete and full and accurate records. There is and I guess it really caught everyone by surprise, at NEOBA, they have what is called a clinical file for each child, and then they have a non-clinical file for that child. And the counselors testified about things that were not contained in the clinical file, but were actually contained in the non-clinical file, such as the child's records, about drawings, lists that the child made. And in fact, I asked, what is contained in the non-clinical portion of the records? Child's registration, diagnostic assessment, clinical notes, the goal form, artworks. None of those were introduced, even though they were talked about. So I said, under the Rules of Evidence 106, I'm entitled to make the state introduce all the records for the court's consideration, because it's not complete and accurate. And they testified, yeah, it's not complete and accurate. We have the complete clinical records. We don't have the complete non-clinical records, even though we can't distinguish exactly which goes into which file. Now, this court held, back in 2006, in re S.J., and this is on page 14 of my main brief. We are reminded that Evidence Rule 106 uses the peculiar language an adverse party may require. These are not words of discretion. So, it is mandatory, once I invoke Evidence Rule 106, Rule of Completeness, I want all the records introduced, they are to be introduced. Now, and it goes on in this paragraph to say, it was error for the trial judge or the magistrate there to say, well, I don't find that the missing portions are relevant, so I'm not even going to look at them or consider them and determine. I'm not going to, and the court said that's error on its face. You have to first look at the portions that are not being introduced, and then you have to make a determination, should they be, if they're relevant or inadmissible for whatever reason, and by not even looking at what's missing, that's error on its face.
What's in the record as to what those missing records would contain, generically? What is in?
The counselors testified, it does not, the non-clinical portions include child's registration forms, diagnostic assessments, clinical notes, the goal forms, artworks, and in that case, the child made a number of lists about things in the child's life that happy or unhappy that the child likes. Those were also all in the non-clinical portion of the records. So the judge, when I said I want these records introduced, or I want the state to introduce the full record, she says, I don't find those missing portions relevant.
Well,
so,
that was the question I was going to ask.
Right. She said, I don't find them relevant, so overruled.
Why are they relevant?
Huh?
Why are they relevant under the circumstances of this case?
Well, first, the counselors testified, the child drew pictures about family and my father and my mother and all. So I asked, because I wanted to ask some cross-examinations about the drawings the child made. I said, well, where are those drawings? You told me you have the full list of records. She goes, oh, those are in the non-clinical portion of the records. I don't have those. So then I said, well, under the rule of completeness, I want all those records. And then the child testified, well, the child also made a number of lists, and this is what the child talked about and all. And I said, well, where are those lists that the child made? Those are also contained in the non-clinical portion of the records. So the judge, without giving any review of the missing portions, just said, I don't find that they're going to be relevant. I don't know what I'm going to glean from the missing portions, and therefore overruled. But that's exactly the situation in SJ, where it says the first, you have to look at the records, and then determine if they're relevant or irrelevant. You can't just say, ipso facto, the missing portions are irrelevant, and I'm not going to introduce, and having them not introduced is perfectly okay. Further, the two counselors said they're not the keeper of the records. They have no knowledge about the archiving system, the retrieval system, the software system, how they're maintained, and the records. So I argued they can't authenticate these records or kept in the ordinary course of business. They have to present some foundation that they have knowledge about the mechanisms and workings of how these records are kept, archived, stored, retrieved. And I asked them, what's the software? I don't know. Well, where are they stored? I don't know. How are they retrieved? I don't know. How are they put in the computer system? I don't know. So they can't authenticate these records anyways.
So you expect, under those circumstances, that some computer expert or somebody testify as to the processes used in computer record systems?
Your Honor, under 8036, the evidence rule for business records, the records must be kept in the regular course of business, entered by a person with knowledge of the act, event, or condition, recorded at or near time of the transaction, and most importantly, number 4, a foundation must be laid by the custodian of the record or some other qualified witness. So somebody who's qualified, who has knowledge and mechanisms of the records, has to testify. They can't just bring the counselor and say, yeah, these look like the complete and full records, and they're, and all that. That doesn't meet the hearsay exception of business records. So we're arguing that was not done in this case, and that was inadmissible on that basis. Fourth assignment of error. During the case, during the permanent custody, the CSB caseworker testifies, says, the prosecutor asked, in your opinion, what's in the best interest of these children, and that for permanent custody to be granted? I object and say, Your Honor, the 9th District Court of Appeals has already held a caseworker can't testify as to the child's wishes and desires or determine or make an argument as to what's in the best interest of the children. Only the guardian ad litem can. And this court has said that repeatedly and repeatedly. Only the guardian ad litem is authorized to testify on behalf of the children and express their wishes and desires. Now, they're saying, well, the guardian ad litem testified, so therefore, so what? Well, we're not disputing that the guardian ad litem testifies the child's wishes and desires and the best interest. That's their role. But this court has said the caseworker can't testify to that, the mother can't testify to that, the father can't testify to it. Nobody is authorized to speak to the child's wishes and desires but for the guardian ad litem.
And you're just now reaching that 3 minutes.
Thank you, Your Honor. Very quickly, fifth assignment of error. The counselor who testified, when they called her, the state said, we wanted to have her declared as an expert. I said, Your Honor, I was not given any notice that the local rules specifically require, local rules list, you have to list all your witnesses, and then specifically says you have to list your expert witnesses with a copy of the curriculum vitae provided to all the parties. That wasn't done. I said, I haven't been given any opportunity or notice, I don't even have the curriculum vitae to cross-examine her. The judge says, well, I've used her as an expert in the past, so therefore objection overruled. We'd argue, I wasn't given any opportunity or notice to challenge her qualifications as an expert. It was totally sandbagged on behalf of the state, just in the middle of the trial for the first time, after she started testifying, we want her declared as an expert. We're arguing that was fundamental error. And then most importantly, Your Honor, the agency only gave my client less than 3 months from the adoption of the case plan to complete before they filed for permanent custody. In a recent case, this court held 6 months. It's just insufficient time to reasonably complete a case plan. Here is less than 3 months. And he visited the children, he did a parenting assessment, he did counseling, he did drug urine screens. He did as much as he could, but within that 3-month time frame, that was simply insufficient. And they're saying, well, it's permanent custody and we can grant it. 3 months is more than enough time. So with those, Your Honor, I think the lower court this court should reverse and remand back. I'll reserve the balance. Thank you.
May it please the court, Kevin D. Martino on behalf of Summit County Children's Services as the appellee in this case. We are asking that this court affirm the trial court's decision. With regard to the first assignment of error, this agency would argue that this court has jurisdiction. In no way in the brief did the agency argue that an appeal of an adjudication is a final appealable order. What the agency is arguing is that because there was a dispositional order, and when the court ruled on the objection to the adjudication, the court said all prior orders not in direct conflict shall remain in full force and effect, that there was in fact an adjudication and a disposition, which is a final appealable order and would give this court jurisdiction. This case is a dependency, neglect, abuse type of case where the rules allow for the dispositional hearing to be separate from the adjudication, and more often than not, they are after the adjudication. It has to be within 30 days. So unlike a dependency, a delinquency case or a criminal case, the disposition would not necessarily be in that same journal entry. And throughout his brief, he tries to equate this to either a delinquency case or a criminal case. The criminal rules do not apply to dependency neglect cases. When the juvenile rules omit something, then we're supposed to look at the civil rules, not the criminal rules. They don't fit. The procedure for dependency neglect case is different than the procedure for delinquency, and it's certainly different than the procedure for a criminal case. So in this case, there was a dispositional order. In his brief, he was arguing that that dispositional order was basically not adopted by the trial court because the court only said anything that's not in direct conflict. So his argument today is not the same as what was in his brief, and it's an inaccurate statement to say that the agency is taking the position that you can appeal directly from an adjudication decision. And in fact, I believe that argument has been raised by counsel in other cases, and the agency has consistently held that that is not a final appealable order. With regard to the criminal convictions, again, this is not a criminal case. The argument about criminal rule 32C, that argument is not proper here. The rules are that court certified documents are self-authenticating and admissible. There was testimony introduced through Ms. Wessig and through the father's counselor that he had a prior breaking and entering charge and an endangering animal charge, consistent with the records that were introduced. The court did say, this man has a pretty unique name. It's not, Joe Smith or something like that. Beyond that, plus it was, the testimony was consistent with the journal entries. They were certified copies. That has always been enough to make it admissible as far as identification and authentication in a dependency neglect abuse case. Obviously, if this was a criminal case and the document was being introduced as maybe an element for an offense, then yes, we would be talking about criminal rule 32C or something else, but this is a dependency neglect abuse case where counsel and client were put on notice that these were going to be introduced. With regard to the child psychological records, in this case, they are business records. The evidence rule does talk about having knowledge about the way that the records are kept, but 803.6 Division 4, which he was speaking of, does not require that the person who testifies about the ordinary course of business and the way the records are kept have this, advanced knowledge of the computer system, etc. They just have to have the general familiarity of how the records are kept, and there's case law that supports that. In this case, Ms. Tenney testified that she has a general familiarity about how the records are kept at Northeast Ohio Behavioral Health, and Ms. Singer also explained that, Ms. Shearing, she explained that she authored the report and also testified about the way that that agency keeps the records. So that would be sufficient. With regard to this clinical versus non-clinical file, the counselors testified that what was there was a full and complete, accurate clinical file. They said there is a non-clinical file. They said that what would be in there are things like drawings and artwork. To the best of my recollection, that was the type of thing that was in there, and they did not bring that because what they thought was relevant with the clinical records, because that's what they're going to testify about. And then the court heard that argument and made that decision. And under these facts, I don't think that this court could find that the trial court abused its discretion in saying that what was relevant here were the clinical files, not the non-clinical records. And there's certainly no argument or evidence that these drawings or lists would have and somehow been relevant or would have, countered what was in the clinical file. If the expert or the person with the knowledge as far as, psychology, counseling, etc., makes a determination as to what is clinical and what is non-clinical, and they're coming in to testify about their involvement and their expertise, I'm using that term not as, expert under the rules, but just their expertise based on their training and experience and their interaction with the child, then I don't think the trial court can be found to have abused their discretion when what they say is in the non-clinical file is basically drawings and other things that were not relevant to their clinical interaction with the child. With regard to the, yes.
If the treating persons or entity wanted that evidence, wanted the child to produce those drawings, how is it then argued that they're not necessary for the full evaluation?
There's no indication that what was drawn had anything to do with their treatment of the child. There's no indication even that
How
he
do you
can.
prove that? I mean, it's part of the intake, or it's part of the process.
Right.
So how can you make a general statement that it has nothing to do with it?
Well, the statement that I'm making is that if you have a clinical file and a non-clinical file, that person, that entity who is interacting with the child would make the decision as to what's clinical and what is not. And that if this court wants to, come up with a bright line rule that says if there's going to be two sets of records and one's clinical and non-clinical, then there has to be a list of what's in the non-clinical file and a statement as to why that is or is not relevant, that might be, but I think that just on the face of it, that there is a clinical file and there's not a non-clinical file, that someone who has more expertise than I do decided that isn't relevant. That we did the intake and maybe the kid drew something while we were doing it, but that wasn't relevant to my assessment of the intake. So I can't answer that any better than that, and I know I'm not
Thank you.
adequately answering what you wanted. But with regard to the child's wishes, this court has said that if there should have been a guardian appointed and there wasn't, then someone else can't testify as to the child's wishes. But this court has never said that no one else is authorized, as he put it, authorized to speak on behalf of the child's wishes. The goal is the best interest of the child. To me, to say that no one else who has experience, familiarity with the child can say, I think this is what's in the child's best wishes, that this court is, basically telling parties that know this child and want the child's best interest that they can't say what they think their child's wishes. I think that is just in complete, opposite position to what the goal is of dependency neglect cases. And I think that to try to construe what the court said in prior cases that way is inaccurate and misleading. And the cases.
So let me interrupt you for a second. So you're saying, I understand like a caseworker, someone who's been involved with the case, doesn't have to be a guardian ad litem or a social worker or a psychologist or whatever. What if it's the next door neighbor that's been with the child most of her life?
I think it would be based on the facts, but if there was a next door neighbor who knew the child and truly had laid a foundation for why they know the child so well and what they think, I don't see what the error would be from the person
Even
saying.
if it's to stay with mom and dad?
If the court would be able to decide whether or not that person was credible, I don't think it would be error, I really don't. And the guardian ad litem is still going to testify, and that's their job and that's their role, and I think that Judge Teodosio can decide which person to give more weight to, and that ultimately, deciding what's the child's best interest, they're going to listen to what the guardian said. But I don't see how it's error to allow somebody else to say, here's what I know about this child over 10 or 15 years, and this is why I think it's in their best interest. I think that the judge, it's not like it's before a jury, the judge knows what the guardian's role is, and I think she can differentiate, that statement and why the person's making that statement. I don't think it's what the legislature intended to say that if a person, especially a caseworker, can't say, and I think it's in the child's best interest, X, Y, and Z for these reasons. I don't agree with that, and that's not what this court has said before. It was not an issue before the court the way that it is today. With regard to allowing the witness to testify as an expert, that it is true that the witness was only on the witness list, not on the expert list. However, the witness only testified as to direct involvement with the case. I don't think there's any prejudice that can be shown by allowing her to be qualified as an expert. The court didn't just say, well, I've seen her in court before and she's testified, so I'm going to qualify her. I mean, the court made some statements, but it wasn't just a flip it, well, she's testified here before, so she's an expert. But the father was aware that she was going to testify, was aware that Ms. Sharon was involved with the children. She only testified as to her interaction with the children, the testing, and then the results of the test, which is relevant. clearly to this case and not beyond anything that father should have expected Ms. Sheeran to testify to. His last assignment of error goes to the weight and the sufficiency of the evidence, and if there are no questions, I would just rest on what's in the brief with regard to the final assignment and ask this court for.
Thank you.
Thank you.
Council, we have a minute and 25 seconds.
Thank you, Your Honor. May it please the court. I would cite in my brief, Your Honor, for the final appealable order, the trial court must, this is on page 7, the trial court must dispose of all matters so the parties need not consult any other documents to ascertain the court's determination of their rights and obligations as issues. This court has held that a final appealable order is one which does not require review of any other documents or journal entries in order to fully understand the parties' rights and obligations. A journal entry from adjudication that just says all prior orders in effect does exactly that. What prior order? What's the date? What's the finding? What is it that the judge is saying has been adopted by this court? I have to then look at other documents. That's not a final appealable order. It has to be within the four corners of that document. And for the state says on page 5 of their brief, appellant relies on delinquency cases for the proposition that an adjudication is not final without a dispositional order. That reliance is misplaced because an adjudication is factual and procedural distinguishable from a delinquency case. So they're saying there is a difference, but then the state's next sentence is, this case does not involve a delinquency actions and the case law relating to delinquency matters are dispositive to the issue in this case. So she's saying on one hand, you don't look at delinquency cases to determine final order, but those cases are dispositive. And then finally, Your Honor, for the caseworker testifying, this court held, rather than receiving evidence about the child's wishes or best interest from a guardian ad litem or any of the children themselves, the only evidence before the court came from the testimony of the caseworker, the aunt, and the mother, none of who are authorized to speak on behalf of the children. This court emphasized in Henry Smith that only the guardian ad litem is authorized to testify on behalf of the children and express their wishes and desires.
And counsel, I need correction for you that we're spending a lot of time.
Thank you, Your Honor.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision with all parties, as well as post the decision on the Ohio Supreme Court website, which can be linked to our website.
Thank you.
Thank you, Your Honor.